We have one hearing to deal with today, the Jeff Johnson variance request for the town of Bogali. Are you presenting that, Mr. Cheeza?
Yes, I am. I'm going to present that, Mr. Chair.
Okay, the floor is yours.
All right. Thank you, Mr. Chair and members of the board. Today we have a variance request in the town of Aaron Prairie by Deborah Harris. And the site is located at 1373 200th Street. It's located in Section 25, Town 30 North, Range 17 West, in the southwest quarter of the northwest quarter. The property is zoned R1. The property size is 0.5 acres. And the reason why they're here today is because the applicant is requesting a setback variance to reduce the street setback and the rear lot line setback pursuant to section 15.230 of the St. Croix County zoning ordinance. So a little background about this information, or about the property, is that it is a non-conforming lot, but it was created in 1967 and it met the size of a normal lot at that time, which was in the St. Croix County 1964 zoning ordinance. The applicant is requesting a 38-foot street setback instead of the 50-foot normal setback. And they're also requesting a 12.3-foot rear lot line setback instead of 25 feet to a dwelling. The applicant is planning to place a 24-foot by 44-foot manufactured home on the property if the variances are granted. And the proposed placement of this home is in the same spot as the prior home that was demolished back in 2016. So the non-conforming use of the property as a dwelling is no longer non-conforming. That's why they had to come through the variance process here, because they would have had to basically put a new dwelling back in that same place within a year. So that's why the variance is needed. So if we look at the site from an aerial, you can see that we've got 200th Street here, and then here's the little lot. The zoning of the property is surrounded by Ag 2 to the north and to the west, and then Ag 1 to the east. Here's the lot right there. And so kind of the surrounding parcels that are around it, the 20-acre parcel across the street is used for a home site, as well as the 40 acres to the north of the property has also got a dwelling on it. The remaining part of this 40-acre parcel is used as ag production for the most part. It does have a little bit of forest. And then the whole area is pretty rural just in general, with a lot of agricultural use. So here's an aerial photo of the site. They've got a little structure here. Just this kind of an old dwelling site, old household site. So here's the site plan that they're proposing. So 200th Street is your normal town road. It's got a total width of 66 feet or 33 feet of road right-of-way on each side of the center line. So off from that 33-foot right-of-way, they're going to be 38 feet down here. So I don't know if I can zoom in so you can see this better. So the southwest corner of the dwelling would be 38, and then the northeast corner would be 12.3 from the rear lot line setback. And again, 0.5 acres, so the total lot is about 104, and that by a couple hundred, 208 feet. Okay. So here's some photos of the site. So this would be the east view and that from where the house would be. So the house would be kind of laid right in here. Another view just a little bit farther to the south, you can see some mature trees, and that you can see some corn in the background from that ag field that's surrounding it. This would be the road here, 200th Street, and that's viewing somewhat north. Northeast, and that on the property would be up in here, so that would be that far northeast corner. But this would be north of the proposed dwelling site. Just another view of the lot. Viewing southeast, and that'd be the southeast corner of the lot right behind that pine tree there. So this would be standing approximately where the house would be built, and here's the road, 200th. Kind of the same picture of that. The town of Aaron Prairie has provided comment since the packet was published and that, and they did approve of this variance. And with that, we do have findings of fact and conclusions of law worked up for you. But basically what the board needs to consider is the 3 variance criteria, and that is there an unnecessary hardship in that for the applicant to not be able to put a dwelling back on the property? And that is there physical property limitations as far as where the dwelling could be placed? And then also, is it contrary to public interest? So those are the 3 criteria, and then that for you to consider. And of course, you can deny, you can approve, or table the request. Okay, so that summarizes the staff report. Any questions from the board?
If we're going to grant variance, we have to find that it is consistent with the spirit of the zoning law. What is the reason for a highway setback to be 50 feet from 200th Street?
So the 50-foot setback is an arbitrary number, and that is what I would say.
Yes, and why is it there?
What's that?
And why did the county board create that setback?
So normally, and that the 33-foot right-of-way from the road is what the towns are concerned about. That is for maintaining of the road, the ditches, the safety of the traveling public, and that as they're driving down the road so that they can take and, cut the trees out of the ditch and whatever. And that the 50-foot setback off from the road, and that usually they're trying to think about, so if you got a garage, for example, and now you're parking a boat or a pickup or whatever in there, and that you're still off that road far enough, and that you're not into the right of way of the road, you're not into the danger zone for the public as they're traveling by, and that. So every town and that, some of them and that require bigger setbacks, some of them are fine with a lot less. So it depends on what municipality you're in.
So you've indicated one of the reasons for the setback is the safety of the traveling public on the highway as they slip and slide on ice and get off the road and run into a boat that's parked within the right-of-way or in the danger zone. I've in the past heard that one of the reasons for the setback is also for the safety of the occupants of the property. Children running out into these danger zone, dogs getting in the street and disrupting traffic and causing collisions. So there's the safety of the residents that's a factor also, apparently. And another reason I've heard articulated is that if in the future public authorities find it necessary to widen a road, they would need to purchase property, and if it is built up already, the purchase price will be much higher. So if, for instance, they need to use eminent domain and pay the fair market value to the owners of the property in order to buy some of their property to widen the road, there will be a much higher expense to the taxpayers if they have to purchase a building rather than just bare land. Are those reasons that you've also heard in your experience, Mr. Cheezick?
I guess it could be, yeah, and that, so, usually, you know, people and that, and dogs and stuff, we're talking about a structure setback, you know, and that, so just because there's a structure that's set back farther from the road, doesn't necessarily mean that those things are still gonna be within that area, you know, and that, or near the road.
Are not gonna be in
And
that
that, so, but yes, and that, in the end of the day, if you set a house or a building back farther, it's got less risk of having people out and about, so, by the road.
Now, one way to minimize that risk, both to the traveling public and to the residents of the home, would be to have a berm that prevents vehicles from getting over there, or jersey barriers, or fencing to confine children and animals from getting into the road.
I suppose, yep.
Yep. Is there any other reason that we need to be cognizant of as we consider what the spirit and intent of the ordinance is with regard to this setback? None that occurs to you?
Nope.
And if we were to look at the words of the ordinance, we would not get any more specifics to consider, I take it?
Correct, and that, again, I would just go back to the 3 variance criteria on that. So anytime we're looking at a variance from the ordinance, the applicant needs to carry the burden that the variance request is the minimum relief needed, and that for, and that their use on the property, so for that dwelling site. So this one here is a 24 by 44 foot dwelling, and that, so is that the minimum? I don't know, that's up to the board. And that also you need to take and consider, and that what the hardship would be if the applicant can't put a new dwelling on this parcel, you know, and that, is it, you know, that they used to be able to, or that they, had a non-conforming use, and that maybe it fits, maybe it doesn't. Then as far as the property itself, you gotta consider the dimensions of the lot, if there's any steep slopes, terrain, anything like that, that would limit the dwelling in that site on the property. Setbacks is one on the Harris one here. And then also, and that is it contrary to public interest, which is the one requirement that we were talking about as far as the setback from the road and the safety of the public and stuff, so.
Are there terrain features that limit the buildable area on this lot?
Nope, and that, the lot is relatively flat.
What is the buildable area on this lot, if any? When you take into consideration the ordinance setbacks and so on, is there any land left on which a house could be built without needing a variance?
Okay, so I'm going back to the site plan here. So if we've got a 50-foot setback from the center line of the road, and that would be coming off from this 104 feet, so that would leave us 54 feet. And then we have a 25-foot rear lot line setback coming off from there, and so that would actually reduce it down to almost no buildable area.
Well, it'd be 29 feet, would it? Of width? Or let me do my math again here. 104
So if we had
minus-
38 and we go to 50, that would be reducing the 24-foot dwelling here down, and that by 12 feet, 50 minus 38. And that, so then we'd only have a 12-foot wide dwelling, and then if we go from 12.3 feet to 25, that would be another 12 to 13 feet, which would reduce the total building size here, if the site plan is correct, and that to nothing, so that there would be no buildable area.
And since it's a rectangle, that applies to the whole site. And the street is almost parallel to the lot line.
Yeah, it kind of kicks off a little bit to the northwest,
right.
so.
So there is essentially
Right here.
no buildable place on this lot as it's currently zoned.
Correct.
Is the adjoining property owner to the, that surrounds this, the agricultural land, do you know who owns that land? Did that come up in your research? Is
I
it,
don't know off the top of my head, no.
this lot was carved off the 40 acres back
Ye-
in 67 or whatever it was.
1967, yep,
Yeah.
yep,
At one time, this was all under one ownership,
Yep.
apparently,
yep, it would've been a quarter.
back that time.
Where is the old foundation compared to this house that's proposed?
Right under it, I think.
Yeah, and that, I believe that it was in the same spot as what it is right now, but I don't believe there's any foundation left, in that on site, so.
As you stated earlier, the old house could have been left there forever because it pre-existed the zoning change and maintained. But did your office get any inquiry? Do you have any record of an inquiry from these owners or anybody else who represented the ownership of this property? What would happen if they took down the old building and didn't rebuild it within a year? They had a year to rebuild it, you said earlier.
Correct,
on
and
the
that,
same
so a
location.
non-conforming use, and that, let's say that the previous dwelling was the 24 by 44, the same size that they're proposing right now, and that, no matter what the condition was really, and that it could have been run down, and that, but if they would have tore it down within the last year, and that, they would have been able to get a permit through us, and that to put it right back in the same footprint, because there's that statutory time frame and that of 1 year for the rebuilding. And that since it was done in 2016, I wasn't with the county. A lot of our staff, I don't think any of our staff almost on board, and that now, we're here except for one that I can think of. And so I don't know what those, communications were back then.
When you looked into the files, you didn't find any indication that there was knowledge when the building was taken down by the owners at the time, probably this Jeff Johnson, that you didn't find any indication that there'd been an inquiry as to what would happen if they took it down and didn't rebuild it within a year.
Not that I'm aware of.
No.
Yep.
I take it that the X in the northeast corner where it indicates soil test is a suggestion of where the septic system is planned to be?
Yes,
And they're gonna build a new septic system, I take it, because the old one is so outdated that it's not useful?
I believe that is the plan, yep.
Other board members have questions? Sure.
With reference to the septic system, how far does that have to be from the house?
So there's, on a normal sewer system, two different components. The septic tank or the holding tank compartment of it, and that needs to be 5 feet from the dwelling. And for the mound system or the drain field portion of it, and that would need to be 10 feet from the dwelling. However, the sewer can go within both of the setback areas if it will fit. Because a sewer tank only needs to be 2 feet from a lot line, and a drain field needs to be 5 feet from a lot line. But the sewer cannot be within the right-of-way of the road.
How far does the well have to be from the sewer?
Okay, so the septic tank part of it needs to be 25 feet from the well, and the drain field portion needs to be 50 feet from the well. So it is possible to make it all fit on this site.
So there is room for,
Yep, and the county allows for holding tank now too as well, and so that would always be an option. That would only need to be 5 feet from the home, 2 feet from the lot lines, and they're roughly, call it 6.5 to 7 feet wide by 13 feet long, so relatively small.
I visited the site yesterday and I see across the road they have a mound system, so that usually takes up more room. Also, you talked about reasons to setback. Plowing snow gets to be an issue too, and throwing rocks by the plow, throwing rocks at the house and things like that too. No, that's all I had, I guess. Used to be 133 feet. But then they reduced that. I'm not sure they couldn't. Something about lawsuits or something. I don't remember now what the reason was.
Yeah, and I remember at the time, At the time of the reduction to 50 feet, there was also a consideration of the area in Boardman, where there are a lot of houses that are built, I guess, I mean, your district, Greg, and there they said 50 feet or in line with other buildings. If, you know, it made some sense that if there was a hazard from one building sticking out closer and having its children and dogs running out in the road, you know, if they were all in a line, drivers would slow down and accommodate that. Here, we don't have another home for quite a distance north and south on 200 on the same side of the street, you know. So we can't apply that analysis here. Any other questions, board members?
Okay.
All right, it's our custom to next ask for testimony from people who are in favor of the application, who would like to see us grant the variance, either exactly the way it is or with some sort of conditions. And after that, to hear from people who are opposed to our granting the variance at all. And then lastly, to people who aren't necessarily for or against, but have a comment to make or some observation that they think will help us make the best decision for the residents of the county. So we do ask that before testifying, people sign the little document we have over on the credenza there by the on your right against the wall. When you sign that, you pledge that your testimony will be true, that the facts that you present will be true as far as you know. So I now ask for people who would like to testify in favor of the granting of the variance. This is often when the applicant and their friends and their agents and surveyors and attorneys and stuff like that step up to talk.
Hello, my name is Deb Harris, and I'm looking at this piece of property from across the road from my sister and brother-in-law to help my sister, who's had 3 heart attacks.
I'm going to just interrupt you. We are bound to follow procedures that treat all people as equal. And that means, among other things, that we will treat you exactly the same as if you were, let's say, a newly married 18-year-old couple without a relative within 500 miles. Or if you were somebody entirely different from whom you are. Now, I guess the reason behind that law is that you're the applicant today, but the decision we make will be perpetual. So there will be, if we grant the variance and you put the building there and it's there for 200 years, there will be, 10 different owners there. So we can't possibly make our decisions based on the personal characteristics of you and your family. Does that make sense to you?
Yes, it does.
All right. Go ahead and tell us why we should grant this variance. It's your burden to persuade us, of course.
I don't know if this is too personal, but I'm looking for a retirement home. I'm retired now, and it's just a nice little property that I would like to acquire. And I'm not sure what else I need to say about it.
And this size of home will give you, what, 2 bedrooms and a 2-car garage, I suppose?
Probably not that big of a garage,
Okay.
but a
2 bedrooms, 1 bathroom,
Yes,
presumably, and a 1-car, 1.5-car garage.
right. I don't need much.
Right. And that'll be a property that will be saleable or that you can leave to your heirs, and it'll be a usable property for the next 200 years, presumably. Did you, no, I'm not going there. It would be highly personal.
And I don't plan to have animals or anything. I used to have horses back in the day when I was younger, but not any longer. So it's just
Suppose
me.
suppose we were to grant this variance on the condition that you and subsequent owners would be prohibited from having dogs. Would you still want to go ahead with it?
Yes,
Suppose we were to require that you put a berm across the front of the property. Now, maybe if you end up with a mound septic system, the berm could be part of that septic system, but it would be on the road side of your house, not up on the north end there. Would you still want the variance?
yes.
Okay. Anything else you want to say at this time?
Not
You
at
can
this
stand by and see what other testimony we get, and if there's anything you want to rebut.
Oh, there is one more thing.
Sure.
So on behalf of all the neighbors, some of them have had difficulty with the new GPS system and the property lines. And I talked to the township of Erin Township, and they were going to consider this because there has been a few issues on that subject. And people have gone back to using the original property lines instead of the new GPS lines. So that's all I know about that subject, but I told them that I would mention it.
Interesting. That kind of stuff is controlled by our county surveyor, who actually works for the highway department, yeah.
Yes.
But apparently they think the system is accurate enough for purposes of highway locations and buying and selling little pieces or big pieces when they need to widen the road.
Right, there was a couple not too far from Mr. Johnson that went to sell his home, and the GPS line ran through his shed, the middle of the shed on the property. And he went to court over it, and the judge said that the original property lines are the ones to actually go by.
Could well been a case of adverse possession. I don't know, did that phrase come up when you heard the story? Maybe he had occupied his neighbor's property by having a shed on it for a long enough time, and the neighbor didn't object, that it became his through adverse possession.
That could be
Just
also.
trying to rationalize two competing ideas. All right, thank you.
Thank you.
Stand by. Anybody else want to speak in favor of the application? How about anybody who wants to be opposed to it, who thinks we shouldn't grant the variance? Yes, sir. Mr. Meyer again, if I remember right?
Yeah, my name is David Meyer. My wife Linda and I purchased the 40-acre property that was displayed on the screens earlier. We've lived in that area now for 2 years. I want to start off by saying that my views here, that I have nothing personal against the Johnsons or Deborah Harris. I don't know them at all, and so all of my feelings here, none of this is brought about by any personal issues. When my wife and I began our house search several years ago, some of the things that were very important to us were privacy and being able to hunt deer on our own property. When we drove into the area of Erin Prairie, we saw these signs that said permits required, which gave us some comfort that we're going to have some protection here in terms of the type of developments that would be going on. When we looked at the house that we purchased, we did notice this small parcel of land nearby, and it was a concern to us what that was going to be used for in the future. But it was so small that we figured there's no way anyone would ever try to build a house there. It looked like at the time it was used as kind of a storage area, and by using the Onyx application, I realized that the owners lived right across the street, had their own house, and I thought to myself, this will never be developed to any kind of housing situation. If I'd have known that this property was eventually going to own a house, I never would have bought the property where we live. I've looked at the property values along 200 Street using the St. Croix County tax valuation website. And I think most people realize that the tax valuations are not necessarily representative of real property values, but it does give you a little bit of a basis. And the average property value that I computed on 200th Street is over $428,000, which is going to be quite a variance from the value of the property that we're talking about developing here. I think it's a dangerous precedence to allow decisions on house placement to be based on a house that was removed several years ago. How do we know all the history of all the land in Aaron Prairie and what kind of buildings were there? It's very hard for somebody searching for property to have any idea something like that would be used to propose future development. One of the things that I saw in the online application for this variance was impacts to surrounding neighbors. And again, to me, this will have an impact on my privacy, my hunting, and the future value of my property. That is all I would like to say.
What do you mean it'll have an impact on your hunting? You don't hunt on the 40 acres that's south of you, do you?
No, but my property is very close to where this house will be located. And I think all of just the activity going on at that property, noises, cars coming and going, will have an impact on wildlife's ability or willingness to be on my property.
I get it. The general suburbanization kind of impact, huh?
Yes.
And then you said privacy, and then did you lastly say that you think it will impact your property value?
I do.
Spell that out, please.
Well, generally speaking, having higher value property nearby kind of raises the water level for everybody. And in this case, there may be other buyers like myself who would say, I don't want to live, I don't want to purchase property where we've got this kind of development going on.
And when you say this kind of property, I take it you're talking about the concept of a home built close to the road on a very small lot, so it appears to be crowded. Are those the factors that you think somebody driving by and evaluating property values would consider?
Yes.
Anything else?
No.
For clarification, where is your property in relation to this again?
I don't know if it's possible to pull up the diagram.
I think it's same side of the street and to the north, right?
Correct.
Yeah.
So it's right here, that property.
Thank you.
And the one across the street is the same owner as the small property here. And then this is an Audrey trust here that owns the other 39 acres roughly.
I would like just clarification, who owns this half-acre property right now? I've seen in the applications that Deborah Harris is the owner, but the recent comments made it sound like maybe Jeff Johnson. Is it possible to get clarification who the actual owner is?
It should be. Our application, the applicant says it's Jeff Johnson. The deed, well, which we had a copy in our file here, was a little hard for me to follow, and I'm a lawyer, so maybe I'm just nonplussed by it. First thing I have to do is find it again. Dang. Anybody tell me what page the deed is on?
I can help you, Mr. Chair. So the owner is currently
There.
Jeffrey and Jeannie Johnson. Jean Johnson. Same as across the road.
Yeah, here's the deed. It says that in 1967, when this was recorded in the registrar's office, the property was sold from a group of people named Aune, A-U-N-E, to Kenneth Johnson and Arliss Johnson, husband and wife. I don't know how Jeff Johnson, it's spelled the same way, Johnsson, how Jeff Johnson is related, if at all, to Kenneth and Arliss. Don't we require that the deed, the proof of ownership be current, Mr. Cheezit? So if he inherited, if those are his parents, Kenneth and Arliss, and I'm looking at page 10/35 in our packet, if they are his parents, then presumably he inherited the property, and there's a document showing that he is the current owner, and presumably the taxpayer. The county likes to get those things right, so we get our taxes.
My only question was Jeff Johnson or Deborah Harris, because in the application that I read, it was a little bit unclear to me who the actual owner was. There was a copy of a check there that had implied that payment had been made. And I was just curious who the actual owner is at this point, legally.
Well, I think Ms. Harris said it was not her. She is proposing to buy the property.
Okay.
She's
all right.
made a down payment, apparently. There's another person who raised her hand who may have some information. If you'll step aside for just a minute, Mr. Meyer. Would you identify yourself, ma'am, and tell us what I'm floundering around for here?
Yes, I'm Jeannie Johnson. I am Jeff Johnson's wife. Kenneth and Arliss Johnson are my in-laws that have passed away. My husband is the youngest of 5, and he purchased the land, the 20 acres, plus the half-acre across the road. We built on the 20 acres across the road, and we are wanting to sell it to my sister.
But your husband did not buy the 39.5 acres that surround this.
That is his relation, the Aunies.
Some of the other 4 siblings, I gather, or their descendants.
No, it's Arliss Johnson was an Auntie, and Jean Auntie was the other owner. So they were brother, sister.
While you're there at the microphone, is there anything else you wanted to tell us or point out to us or say to us to help us make a better decision? Obviously, you want.
I might raise my hand again, I don't know.
Sure. We might
Thank
go
you.
around again once more.
Thank you.
All right.
Mr. Chair, if I can jump in, just for the clarification on the ownership, and that they took ownership of the property on April 10th of 2012, and that was document 954-134 at the Register of Deeds office, and it was from Arliss Johnson to Jeff and Jeannie Johnson.
Thank you for the clarification.
So it's owned by Jeff and Jeannie at this time, just as the 20 acres across the street is owned by them.
Okay. Yeah, I wasn't sure if the transfer had already occurred, so thanks for clarifying.
4 years later, they took down the house, and 8 years later, they're proposing to put this house there. Kind of gets us the chronology. All right. Anything else, Mr. Mayor?
No. Thank you for the opportunity to express my opinion.
Sure. Well, you don't have to thank us. Anybody else in the room want to speak up about, yes, you're first, ma'am, and then you, sir.
Hi, my name is Linda Meyer. I'm Dave Meyer's wife. We are the individuals that own that 40 acres of land, as Dave had described. And I'm just here too, wanting to reinforce that I just, requesting the enforcement of the ordinance as it's written. What they're proposing is a piece of land that's very different than the land that's around it. So we have the 40 acres, so there's a 40-acre lot, there's a 39.5-acre lot. On the other side of that, the landowner owns 120 acres, and then across the street is the 20 acres of land. So you can see this piece of land is very different than what is there in the rest of the neighborhood. And I think you mentioned too, and this was in my notes too, I think we have to think of the future landowners of this property. What we create today is going to live on years and years in the future, and I appreciate you mentioning that. Again, just wanting the enforcement of the ordinance as it's written is what I'm here. And again, thank you for letting me also express my opinion. Any questions for me?
Thank you.
Thank you.
And you, sir, had your hand up next.
Good morning, my name's Eric Awney. My family owns a 39.5 on the east side of that half-acre lot. It was my father that ran that land up there. I farm it now. I've since taken over since my dad passed away. So we have that 39.5 acres, and if you look at that survey, if they put the house where they're proposing it with that setback at 12.3 feet, that'll put our farm field right at that 12 feet where I do crops. I mean, that's basically where it's gonna be at. With that recent survey also, I'm assuming my mom doesn't recall, obviously it was 57 years ago when they sold that land to my aunt and uncle, Kenneth and Arliss. When they sold that land to them to put that house there, this went through my grandpa also, when he originally owned that chunk up there. Why the fence got put where it was, I don't know. Back then, obviously, we don't have the GPS, or they didn't have the GPS and all the ways of measuring. Where the fence is now, you can see in there that the fence remnants, which isn't maintained. There is some trees that have been overgrowing in there. It's almost 30 feet is where that's at, where that old fence and the tree line is. With this being done and the new survey done going through there, it obviously cuts quite a bit of that off. The fence was misplaced, put in the wrong place, or they had a verbal agreement back then. I don't know. My dad ran cattle on that also up there years ago. So I will be putting a new fence back in there just to get that property line set, because if this does pass and she's able to put a house on there, she could sell it a year from now, and I don't have to keep dealing with this over and over, so it's gonna get a fence put in there. But that, like I say, that will put our property line within 12 feet of a dwelling back there where I do agriculture. And like was said earlier, I think if you allow this to go through, who's the next person to come in and say, well, you did it for them, you're gonna do it for us also? You're cutting quite a bit off of the setback rules already, if this goes through. I can say, like, I think the big thing, like you had mentioned too, the plowing of the snow, how much that get wings out. If you're actually physically there, you said you've been to the site, that will be very close to the road. And it is a fairly busy road, it's a back road, but it's busy enough back there. I think having that close to that road. And I guess my only suggestion, or something we brought up, it doesn't prove any hardship on Johnson's when they own the 20 across on the west side to not be able to sell this half acre. Why not prove it to put a house on the west side of the road in that 20 acres if she needs to be there and get it off the road to meet the setback rules? That's something that could be proposed too. And it wouldn't be any less hardship than it would be not to be able to sell that half acre he's got now. You follow what I'm saying?
Yeah, I did, and I just want to clarify the record and then ask you a question.
Yep.
I take it you're looking at the so-called map of survey,
Yep.
which in our packet is page 11 of 35, and you're noting that the surveyor found fence remnants at the northeast corner and the southeast corner.
Yep.
And sketched them for our purposes here, and we have a scale. you estimated that the distance from the actual surveyed property line to the fence remnant is, in your estimate, about 30 feet. And I'm looking at the scale, and that looks about right.
Yep.
Well, so that prompts me to ask a question. For all these years, and you say it's grown up with shrubbery and trees and whatnot, for all these years, you've not been farming the section between the so-called fence remnants and the property boundary.
Nope.
Why not sell it to them? And if you sold them 30 feet, that would solve our problem, I think.
It's never been brought up. I've proposed over the last several years since they tore that house down, 8 years ago, and it actually sat vacant for several years before that too, before it was torn down, to sell me that half acre up there so we can make a complete 40, so we'd have two 20-acre sections up there. This house goes in there, it could be there for my lifetime, and it'll never happen. I'll never be able to have that, those two separate 20 acres. Yeah, when I proposed that and what the story I got, what Jeff had told me is that it was in my family, I want to keep it in my family, it's where I grew up, kind of a thing. Well, now if you can sell it to a sister-in-law, she could sell it 6 months later, and it
Well,
could be gone. You know what I mean?
yeah, sell it or
it's-
not, she's not gonna live forever.
Oh, none of us are,
As I'm
unfortunately.
not going to, yeah.
Yep. It's always an option. But where would that still put you? Because you already, that would put you right at that.
I think we were down to 0 or minus 3 feet, weren't we, when we did our math there? If we added 30, we'd have plus 27, and we need 24 to fit this building in.
Right.
So it looks, and you know, maybe 30 isn't precisely the distance of the fence remnant to the lot line. When you got out there and actually walked it off, you might say, well, my farming would still be just fine if I came to this edge here. And that gives you enough room to put your building in there.
As of right now, we're not in a position to sell any more of that land up there, I guess is kind of where I'm at.
Sure, I know it wasn't your idea, it was my idea.
Oh, nope, nope, and it's.
But you haven't been able to farm it
What we
because
gotta do is
of
throw the ideas out, that's how you get things taken
trees
care
and
of.
stuff.
Yep.
On the
yep.
other hand, are you almost in a position to be able to just buy this piece of land from them?
Yes, we could. I
And
could,
then-
yes.
then
At-
maybe-
At a market value, I mean, obviously, it's not $100,000 property, you know what I mean?
No, what did Mr. Meyer find when you were looking for it? What does the tax assessor say it's worth as a vacant lot?
I don't remember seeing what that was, but my understanding was that the purchase offer is $10,000.
Well, I don't know, we can get that confirmed in a minute. I thought that might be the down payment, but, yeah, for that matter, we can look up in a minute what the tax assessor says it's worth.
And
Yeah,
I proposed it, not to cut you, I proposed it to Jeff to buy that and then build on the other side, see if you can get it approved to go to the other side. Obviously, you'd want to know beforehand. You know, and I think that would cure a lot of the problems they have right now with that setback. You wouldn't have to change that and cause future problems for other people standing up here wanting the same thing.
Yeah, I'm mindful of that, believe me. Other board members?
If you'd like an answer,
Mr.
Mr. Chair, to
Chizek
the
has-
question, the lot that we're talking about is currently assessed at $5,000, but the estimated fair market value is $6,000.
Oh, all right. Yeah.
Thank you.
Well, I guess 10,000 probably is the purchase price that you agreed, is that right? Yeah, I'm seeing a nod from Mrs. Harris that she and her, well, maybe her sister gave you a little better deal than market, but it's somewhere in that vicinity, plus or minus 10, 15%. Would you buy it for that?
For 10,
For 11?
I would do 11 on it. I wouldn't, if they would accept that offer. Yep.
That would cover their surveying expenses to create a lot carved off from your 20. Step aside just a minute and let
Well,
Mrs. Johnson step up here.
Yeah, that could be doable, but the land that is on the 20 acres has to be built up with sand and fill and a new driveway, and it's already, the existing half acre already has a fire number, a driveway, the, what do you call it, that goes under the
Culvert?
driveway? The culvert, thank you
Yep.
very much. And it's already built up high enough to where our 20 acres is marshy, to be honest with you. And it would have to have sand, dirt, and that would probably cost 10 grand, give or take, to put in culvert, driveway, all the sand, all the, to put a house. So that's all I was.
Yeah, well, thanks for,
Thank you.
thinking about it and staying civil as we discuss what I'm sure is not your first choice.
Thank
Yes.
you. Yes, thank you.
I guess I have nothing more, so I mean, I think we covered it all, so I mean, if we got options out there too, so,
Well, let me look at one other possibility here
Okay.
now. Let's suppose that we work this the other way, and you were selling them a strip of land roughly 30 feet wide. That would be approximately 1/3 of the lot width. Again, I'm looking at that same surveyor's page 11 of 35. So the lot is 104.35 feet wide. And the fence remnant's it says about 30 feet away.
approximately, yes.
Yeah. So if that's roughly 1/3. So 1/3 of $10,000 is $3,300. So would you sell them a strip so that they could then build the house and have it properly set back and with a proper setback from your field, for something in that neighborhood?
It's something you could entertain. I'd obviously have to, this is in a trust, so I'd have to go through my other siblings and my mother. She's still, that's my mother back here, so.
Oh.
She's staying out of it. So that was something we'd have to talk, and obviously Jeff is not here to talk to him about it also. So
Sure.
that's something we'd have to talk about
Yeah.
later on, but.
Yeah. Do you think you could get it worked out in a month before we meet the next time?
Probably could, yeah, we can talk it over.
I mean, nobody's making commitments here. We're just
Right.
tossing ideas that actually you'd take us off the hook, You're having to make a decision, which we've already got some opposition to it, and representing the whole interests of all the residents of the county, we really don't like to make bad precedent.
Right, and then even if we were to still sell that land to them so they could put the house on it, it still goes against what, Dave brought up too. And there are other neighbors up there who have said things they didn't show up today. So
Yeah.
puts me on the hook then. You know what I mean?
There you go. You didn't ask for this.
Yup. Somebody's gonna be a bad guy no matter what, I guess, but yeah. I don't have any more. I can discuss this with the Johnsons too, and obviously, like I say, I gotta discuss with my family. Like I say, it's in a trust, and my mom is the owner, so that's something that I'd have to discuss with her too. But she wants to remain neutral in all this, so.
Well, if you reach a deal, then she would simply be the signer. She'd have to, if she is still the sole trustee, if it's a normal trust, again, this is a part of the law that I dealt with a lot, she would have the authority to trade property, to sell pieces for fair market value, stuff like that. And that wouldn't have to be an impediment, and doesn't mean that she's doing anything to favor one part of the family against another part of the family.
No,
Which,
not at all.
of course, she wouldn't want to do. In a sense, whatever we do here, we'll still keep it in the family, in the larger sense, your grandparents and great-grandparents and stuff like that. If we were, and I'm way out on a limb here, I'm speaking only for myself. If we were to put this off till next month or till our next meeting. It might not be exactly a month from now. Could you, Mr. Cheezit, or assign Mr. Wozniak to convene a meeting of these people and facilitate them? You know, you don't have to say yes or no, or you've got to do this or you've got to do that, but just a neutral ground on which they could meet in one of our new
Mr.
fancy.
Chair, I'd like to take and back up just a little bit and that.
Because you don't like
before-
this kind of stuff at all. You want us to say yes or no. I know you do.
And, well, so here's the problem with a 30-foot strip being added to the east side of this parcel, is that the total lot size of that parcel, and that would still be substandard to today's standard. So then instead of having a reduced setback variance in front of you, you'd have a substandard lot variance in front of you. And that, so they would need to take and at least get almost another acre in that, or around another acre in order to have a conforming lot there. So it is a lot bigger deal than just 30 feet. And I don't think it is the jurisdiction or the authority of any of our staff to take and act as a mediator and that with a land transaction, because,
How about a convener? Think of yourself as a convener for the moment, solving a problem.
I don't think it's our role in that to be in that capacity. And that I think in that the applicant, and that if they want to go and exhaust some other ideas, that's up to them. Otherwise, I would just urge the board to take the application on its merit or on its face value and, either approve or deny accordingly. And I think that you have grounds in that to go either way, depending on how you consider what those criteria are and whether the applicant has carried the burden that they meet the criteria.
Mr. Chair and Board, if I could just make one comment real quick, too. There were a couple comments that suggested that the board's decision on this variance could set precedent. I think the board, you're aware that variances don't set precedent. You have to consider each on its merits. And so I just want to make clarification, whatever your decision, whether to approve, deny, approve with conditions, it's not setting precedent for the next one. You'll have
Yeah,
another
that-
one
I
come
know
before
that.
you.
I know that's what the Supreme Court says, but they don't have to live in the real world, in my opinion. All right,
40 years, and I've been advising boards of adjustment the same way.
Of course you have, and I've been practicing law since 1971, and I would give the same advice. Now it's 9:33, and I think we deserve a break until 9:43. So we're taking an adjournment. Stand by so I can talk to you all. Well, it's 9:43 now. And we're all here, so we're back in session. I'm going to say that I think I see a possibility that the applicant and their neighbors can solve this by themselves. That at worst, we'll be asked to give a variance for the lot size, but not for the setbacks. And so I'm gonna ask board members if you are willing to defer this to our next meeting and give them a chance to work it out. I know, that's very unusual. Probably most of you have never seen us do something like that. And it may not work, there's no guarantees. But I think that's the best thing. So I'm not gonna close the hearing. When we meet on this again, we will probably have new testimony. Yeah, we'll need a motion to sometimes we call it tabling or otherwise deferring till the next meeting. Yeah. And it won't necessarily be this week of the next month, because one of the things we have to talk about is our meetings during the holiday season, so the staff can take some vacation. Yep. No, we don't deserve it. So if anybody's willing to make a motion or else.
Mr. Chair, can I just provide on that some clarification or ask for some clarification? So I just want to make sure that the board is aware that if they're going to be modifying any lot lines out here, that they will need a survey, and that to do it, they'll end up surveying what's now the half-acre parcel. They'll have to get it up to 1.5 acres or have the variance for the substandard lot. And then the remnant parcel will also have to be surveyed as part of this, because that's what our ordinance requires. Also, and that the parcel around it is zoned Ag 1 and that, versus this little parcel is zoned R1. And so right now, the way the current Chapter 15 ordinance is that they would have to rezone that little strip of land and that into being R1 and that instead of Ag 1 in order to combine it on. So there'd be really a rezone that has to happen. They would need to have a survey done. And I would assume that the board would want to take and have the new proposed surveyed lines when you consider an application for a substandard lot. And so I don't think that, I know that all can't be done by next month and that, so we're probably, and that if the surveyor could get on it right away, just in our process, going through the Community Development Committee, the county board, all the public noticing, and that we're looking at 3 months minimum, so.
Well, we could approve it, subject to the condition of the survey being accomplished before the building permit could ever issue. But did you say that the remnant parcel needs to be surveyed too? In other words, surveyor needs to put stakes at the corners of the 39.5 acre piece?
Correct, and that, so it'd be a 2-lot certified survey map in order to take and move those lines, and lot 1 would likely be the smaller parcel here, and then the lot 2 would be that other 39-acre parcel.
Okay, we have some complicated rules, don't we? But they're all for good purposes. Some of them the board can grant variances on, like the area. And you said it's, in this area, it's a 1.5 acre minimum for a new building.
Correct, and the reason why those remnant parcels are now required to be surveyed is so that we avoid issues like this where the old fences and that are way off, and that because of the meets and bounds, and that the old surveyors did a very good job with what they had. They were pulling chains and that, and they had a wheel and that they were measuring out. I always say it's amazing they got as close as they did with everything, but that is why.
Okay. Supposing that we were to defer this until the applicants ask to have it put back on our agenda. So if they reach an agreement and they're getting estimates and they're getting surveys and they want to wait until 2 months, just to get those things done. It's in their hands when it next becomes scheduled, so that we would take it up not earlier than our next meeting, but later if you wish to. And you would control that, Ms. Harris, as the applicant. So you'd tell the staff in time for them to put it on the agenda. I'm not going to close the hearing here because, as I said, I think we'll have new factual input when we take it up the next time. That is, if we do get a motion and it passes. Is that reasonably clear? Just nod your heads. The record will show that everybody seems to understand this. And my apologies to Mr. Johnson. Well, I mean, if he had been here, he would have heard this. Recollect, Mrs. Johnson, that our meetings are recorded, and it's not fun, but you can play them back. So he could hear all the stuff that we went through and the reasons why we got to where we are before you have the meeting with Mr. Aoni. Yeah. Mr. Meyer?
Hey, I'd like to ask a question.
Step up to our mic so that when they go to review this.
Yeah. Well, you mentioned there might be kind of one last round of comments, and I know there's a lot of talk about this extra 30 feet, and my understanding was one of the key components of asking for a variance was to prove that this was not going to have an impact on your neighbors. The fact that we're entertaining that type of discussion, does that mean that my impact statement has no effect on this decision?
Well, speaking for myself, I wouldn't say that. I would say that your input has had a major impact on this decision. That, you know, were we to take a vote on whether to grant this variance right now, I would certainly say no, don't grant the variance, that it is not in the best interest of the neighbors. It doesn't meet that criterion about affecting property values. And by the way, we now know it's not just 30 feet. It's got to be 1.5. Well, it could be as little as 30 feet to get the setbacks. And then we'd have to grant a variance from the 1.5 acre standard. No, I think everybody in the room recognizes that if we grant any kind of a variance to put a house on this small lot, we are making an exception from the ordinance.
Thank you.
With your permission, board members, I'll state the motion, and then you can decide if any of you want to second it, much less if any of you want to vote for it. The motion is to defer further consideration of this matter until a meeting of the applicant's choosing, not sooner than our next meeting. Hearing remains open.
I'll second.
Anybody want to second that? Oh, thank you for rescuing me from my own creativity, whatever. Further discussion? You ready to vote? All in favor of deferring it as stated, please vote aye.
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 And opposed, nay. Okay, that's unanimous, thank you. We'll probably see you all again. I'd offer to convene the meeting, but for much the similar reasons why the staff can't do it, as a voting member, that really puts me in a real box doing anything that's not in public, and such a meeting would not be in public. So, sorry, you're gonna have to figure out your own way to get together over coffee or pizza or a deer stand, whatever. You can certainly ask questions of Mr. Cheez-It. He and Mr. Wozniak are very knowledgeable and can help you navigate your way through the requirements of the ordinance and frame up a variance if one is needed ultimately.
I do have one
Yeah, go ahead. Step up to our mic so that everything is public here.
So even if we were to sell them another parcel of that land to make an acre and a half, do you not still need 20 acres to build in Aaron Prairie? Or is that something you guys are gonna, see, I always thought it was you had to have 20 acres to build in Aaron Prairie. So are you gonna allow the variance of that old house being there, which you guys kind of made the point that it's been gone long enough that it wasn't within that year to grant them that permit to build another home?
Yeah, well, let me stop
If
you.
I'm using the words right, I guess.
I think you may be thinking about the subdivision ordinance.
So the 20-acre minimum to build, that would be a town standard, and
Yep.
so the Board of Adjustment doesn't have anything to deal with that. But the town of Aaron Prairie has approved for this parcel to have a lot on it. So evidently, they're allowing a variance to their own standard for this case.
So they would have to go back and improve again before we can end up here again if we change that lot line in one day.
Correct, and so that's where I was saying that the process is quite lengthy, actually,
Right.
because we're gonna have to take and change the zoning classification, which then is gonna take the town to approve of that. And then we're gonna have to go through and modify the lot lines through a survey and stuff and that, so yes.
So it's basically starting all over again, is what we'd have to do.
And, correct, and we have to take and notice the hearing again, because that, reduced setback variance is much different than a reduced substandard lot variance. So, in order to comply with state law, we have to republish again, so,
All right, so it's not a reconvening, it's starting all over,
correct.
pretty much.
I don't see it that way, but we can get an opinion from our corporation counsel
Okay,
if we need to.
a lot of open ends on this one.
Yeah, a lot of open ends. Actually, the best, would be to find a place for Ms. Harris on the west side of the road.
Right. Okay. Well, we'll see if we can come up with an agreement on it, we'll talk it over, and then maybe make it just easier that way. So, but I just wanted to bring up that 20 acres, because now they'd have to propose on that other side of the road then too, and get that approved in the township. Aaron Prairie, you know what I mean?
Yeah,
Yeah,
yeah.
so
But
it's-
presumably, and, Mr. Wozniak will remind us that each decision stands on its own and one is not a precedent for another. But presumably, if they were willing to say yes to this one, they should certainly say yes to either of the other options.
Okay. All right, well,
Well, thanks for the entertainment, huh?
entertaining, isn't it? Yes.
Yeah.
Learn a little bit too.
Little
Thanks.
course in civics.
Yes, thank you very much.
Yep, okay. Now, do we have something easy? Why don't we take that one, which is just, the third one on our agenda and get that out of the way? Yeah, it's really a rewrite by Mike to cover some stuff he left out the first time, I think. The Shima variance.
Yep, so here it is, and that Mr. Wozniak is gonna take and go through the changes since I wasn't here at the September meeting, so.
Right, and we missed you, but we understood it was for a good purpose.
As requested by the board on this, on the Shima variance request regarding keeping horses on their property in Kinnickinnick, the decision document was adjusted. The couple things, under number 10, and if I can just cursor down here. Under number 10, under the findings of fact, conclusions of law section, basically the italics put in some verbiage that basically comments relating to how this request, approval of this request conforms with the criteria, or if it's not, they're not relevant. And if you have any questions about any of that verbiage or would like anything to read differently, you can certainly.
Well, I do, yes. In 10 sub 1, the italicized language, should it not say the variance request is related to a hardship not based solely on economic gain or loss?
Okay.
Do you agree? Because if it was based solely on economic gain or loss, we would not be empowered to adopt it.
Yeah, staff, that makes sense as far as staff is concerned. Just a more definitive statement is what you're looking for.
A missing negative. So the word not would be added between between hardship and based. Move your cursor up to 10, 1, up, up to number 1, sub 1. Not sub 2, sub 1. That cursor won't go where you want it, will it?
Pardon?
We'll take and we'll update it, Mr. Chair. I know where you're talking.
Okay.
Okay, good. Proceed.
Yeah, and so beyond the addressing the criteria, under the conditions for the decision, the board wanted it limited to 2 horses. And so there was it was adjusted, and just perusing to
Number
see-
3.
Number 3, under number 3, we added that. And I think that was all the board was looking for. And I would say, just for your interest, that the applicant actually has already taken some steps to conform with the requirement. There's some additional information on the manure management that they have to provide, but they have time to do that. And they've actually made a physical enclosure to temporarily store the manure. So they're moving in the right direction.
Motion to approve this formulation of the statement of facts, conclusions of law, decision document.
I'll make a motion to approve this
Document.
document.
I'll
This
second.
piece of paper. Tell John Peterson. I know. Any further discussion? All in favor, vote aye.
Aye.
All opposed, vote nay. It's unanimous.
We'll get it adjusted for the chair's signature and let him know when it's available.
Good, I'll try to sign it before I leave today if it's ready. And now we would take up the matter of our procedures, huh? Let's see, I think I kicked off this request, and you've all been studying the bylaws here before, while we were in between things. One of the procedures that's been changed since Mr. Cheezit arrived is the manner in which drafts are made available to us, draft decision documents. Mr. Cheezit's predecessor, Ellen Denzer, would have the staff prepare a decision document and include it in the packet. And it was then, normally it was only a couple of days before our meeting, so it was a kind of a last minute thing quite frequently. But it was available to the public along with us. So we had an idea in advance which way the staff recommended, whether we approve or disapprove, and then the staff's workup on the reasons, to satisfy the requirements of the 2 principal state Supreme Court decisions that tell us what we have to say as reasons, how specific we need to be. For reasons that are good reasons, the staff has declined to do that subsequently, And now they may work up a decision document, or they may not, but more typically they do, but they don't make it available until they have seen generally which way the board wants to jump on the basic question of to do it or not do it. And I'm talking primarily about variances, because, you know, with conditional uses, we extremely rarely would say no. I can't remember ever saying no. It's a matter of the conditions, you know. But with a variance, we have to say yes or no, and then conditions may or may not be part of the document. So I would recommend that we ask the staff to do something like this. You know, there are three kinds of decisions we can make. We can do variances, we can do conditional use permits, and we can do appeals from staff decisions, which usually have to do with the staff interpretation of the words in an ordinance. Maybe the last time we had one of those was whether crushed gravel was pavement or not. Some of you might remember that one. It was a storage facility, and he wanted to have crushed gravel and have it treated as pavement. And the staff said, no, crushed gravel is not pavement. That's not what the county board meant when they passed the ordinance. And we agreed, but we had to hear that appeal. Then there are conditional use permits, which we almost always approve because they're on the list of approved conditional uses. It's just that we have to say what conditions specific to this application make it appropriate with the spirit of the ordinance. And then variances where we have those rather difficult criteria that we have to decide that the applicant has proved their case. I would suggest that we ask the staff to treat those, two of those in the same way. Conditional use permits and appeals, that they provide in advance a decision document that would approve, unless they, you know, are persuaded in the 1,000th of a case that we can turn it down, and should, and list the facts in support of the approval and the conditions, you know, the approval, the support, and the conditions that they recommend for both conditional uses and appeals. But for variances, I would suggest a different approach, that the staff be asked to provide two documents, one approving and one disapproving, listing in each case what are the facts that support approving, what are the facts that support disapproving, and if they propose conditions. So the staff is not taking a position for or against a variance, but are forcing us to make the decision, which is where it should be. That's why we're paid the big bucks here. But they're giving us all the support they reasonably can to marshal the facts. Now, even if we do that, remember that in every case, the hearing may give us new input, new important facts, or the site visit may give us new important facts. Nobody can anticipate that. There's nothing the staff can do about that. They do the best they can with the facts they have. But by their providing us some kind of draft document, they do us a tremendous service. But we shouldn't force them to make a decision until we have taken the heat for the decision. That's my reasoning. Now, I'd like to hear from Jason about it, and Mike, if he wants to weigh in.
Yeah, thank you,
And then
Mr.
we'll go
Chair.
from there.
And so we did provide each board member and that with a copy of the procedures, and that for the Board of Adjustment here that was done. It's been around since 1994, amended in 2015. Also, the Board of Adjustment operates under Wisconsin statute 59.694, okay? And when we look at variances and that, underneath that statute, it provides the process and that for going through these applications. For example, we had Mr. Meyer here today question about what is the public notice, requirement, and that is a Class 2 public notice under Chapter 985. And so why do we do this? Why do we have a Board of Adjustment? And the whole intent, I believe, of the statute, and that is to be impartial board members, and that you don't come in with a preconceived, biased opinion, or that staff isn't influencing the Board of Adjustment too much and that ahead of time. Because really, those motions, I guess, and that you would make to approve, and that are truly your motion, not staff's. Furthermore, I don't necessarily have a problem recommending approval or denial, but I don't really like that word. I usually call it suggesting, so if we're suggesting and that approval with these conditions, and that, again, we're not the actual BOA members making that argument. So you understand kind of how the process goes with our staff in-house. We meet with applicants and we try to take and advise them on whether or not their variance will be approved or denied to the best of our ability. On that, sometimes we get some pretty crazy, way out there ideas, and we're like, hey, it's pretty hard to meet those 3 variance criteria for something like that. You can apply, but I don't think it's going to go very good. And if we start providing 2 different, an approval and a denial, some of them just simply we won't be able to do because it's hard to be two-sided on some of these topics. But it's also going to take and reduce the credibility of our staff, because we're going to be providing it both ways, Also,
Why do you say that? It shows that you're open-minded, doesn't it? That makes you more credible.
So how does staff advise applicants in that effectively then, and that saying, yep, that's a pretty outlandish idea. It's probably not going to fly. And so we advise them that way, but then we come to the packet and we've got both copies provided, so it's like.
Yeah, so you say to the applicant, you gave us these facts. It's your burden to prove. Here's what you gave us. We put it down for you. Don't think the board's going to agree, but the board has asked us to state the best case for each side, for or against. I don't see that making you less credible. I see it making you more credible, with all due respect, Jason.
And there is a fair amount of staff time that goes with this, and that if we're taking and drafting 2 documents and basically one of them's going to be wasted because we can't make 2 different kinds of motions. As well. So that's a concern of mine as far as staffing levels, because now instead of having our staff doing their normal duties, permitting and stuff, and having a fast turnaround for the public, now they're doing extra work, and that's really not going to be needed, so that's a big concern. But what I'm going back to is the due process. So like the Harris one, and that the county policy is to get the agenda packets out 1 week from the day of the meeting, so a week before. And so that's why we've been getting it out, on the Thursday before your meeting. And so, but with Harris, we hadn't heard from the town of Aaron Prairie yet. And so information changes, and that right up to the day of the hearing itself, and that has information that is revealed to staff, and that we didn't know before. And so I think it's unfair to staff to really make them come to a conclusion or a decision, and that which would be predetermined, and that without knowing all the information. And I think legally, somebody could challenge us, and that the board members are coming in with a biased opinion because they've got it in their packet, how the hearing's already going to end up and go, for that.
So you're basically saying you don't want to do any decision documents in advance because they suggest you've already made up your mind.
Correct. And I think that
So
violates the due process, and that is intended by the statute, so that that's why we have a Board of Adjustment, that's why we have a hearing, so that people can come, they can talk about their application, they can explain why or why they don't meet the criteria, and like I
So you're
said,
gonna, you would like to discontinue preparing any decision documents before the board meeting?
and that, I believe in that staff should provide a good staff report with the facts of the property and the facts of the application, the information behind it, the pictures and stuff, and that for the board to be able to take and make them action item on that request. I'm still willing to provide the suggestion and that on the day of, but I think.
I don't think you should provide a suggestion that is only one way, because that suggests favoritism or bias. See, that's the problem that you just described. Now, do you think that same analysis applies to conditional use permits and appeals as well? That you would not want to prepare decision documents in advance?
So with appeals, and that somebody is appealing staff's opinion or stance on a particular matter, and so would it make sense to take and have staff support themselves on that appeal and then also say, yeah, I'm wrong, and that you should deny and that, or support the appeal, approve the appeal, so that doesn't make sense for appeals.
No, that's why I didn't recommend it.
And for conditional uses and that, with those underneath Act 67, and that you basically have to approve conditional uses as long as there is substantial evidence by a reasonable person and that the applicant is willing to grant or follow conditions put on by the Board of Adjustment.
So you,
So that's pretty much an approval only too, so.
yeah.
Mr. Chair, could I just,
you're-
on the
just a
appeal
minute.
issue,
Just a
comment to
minute,
you?
Mike.
I'll get, yeah, I'll hold.
Just hold that thought.
Pardon me.
Yep. So, you are, willing to provide decision documents in advance for conditional uses and appeals, right? Am I hearing you right?
Well, definitely appeals, because staff will be taking their
You've
stance
already-
on it, and
Yep.
that conditional uses, yeah, we can, and that, but we might not have all the information from the town, so,
Or other sources, yeah, other things may happen.
yeah, I
Might be
mean,
a weather report.
the DNR has been, perfect at coming in at the 11th hour on all the variance requests that we have, and so our staff don't have the ability then, it's already published on the county website, and that here's, staff's suggestion on how to proceed, and now they have no ability to go in and actually correct their opinion, and that because the DNR provided comment at the 11th hour, the day before or the morning of usually. And so it's kind of unfair to staff that way. I mean, these are professionals. I think they do a phenomenal job at doing a detailed staff report, outlining the facts and everything. They're here for any questions and that you might have.
Would you like to not prepare any decision documents before we meet?
Well, we prepare the documents but we prepare them and we are able to amend them and that literally almost on the floor if we need to, so that we create a sound record and so that we're not looked upon if we were to be challenged on something and that we were biased or impartial on any applicant. And so that's how I think that we're gonna be, and I'm not an attorney, and that the most legally defensible, because if we take and put it out there and now all of a sudden the board has a track record of going with staff's suggestion to approve or deny, whatever it might be, and that now we're creating a track record, so.
Now, concentrating for the moment, let's just start with one at a time, appeals. What is your preferred staff involvement on appeals with regard to decision documents?
And so my preferred approach on an appeal would be that staff would do a staff report, that staff would not make any recommendation or suggestion to the board on an appeal, because of course, staff is gonna be supporting their position, why they said or why they acted the way they did on a particular matter. And so and I think really that should be up to the board and that to make sure that you don't have anything from staff, of course, we're gonna be supporting ourselves and that throughout that, but that'll be in the staff report, that'll be published in the packet a week beforehand. So yes, we would not have any decision documents because staff would be basically arguing with themselves, if you will, so.
No, I don't get your point, because obviously staff stands behind its previous decision. Whether you prepare a decision document that lists the reasons in order or not, everybody knows you're in support of your own position.
Yeah.
Why not be forthright about it? Prepare the piece of paper in advance. If we agree, like we did with the pavement question, for example, it's there to be signed. No surprises to anybody. Of course you support the position that you took for the previous 2 months or whatever it takes to get, work its way up to us. I don't see why you need to be shy about the fact that you believe in your previous decision.
No, right,
No,
and
no,
that's
that's
exactly
not
what
what you
I'm
meant.
saying.
So
Yeah.
just do it. You know, okay, on appeals.
Okay,
Now, on conditional uses,
yeah,
we're almost always gonna grant them because it takes an extremely unusual situation to go outside that boundary line. It's a matter of the conditions, right? So why hold back there when you, the staff, have a list of proposed conditions? Why not share them with us? And if you're sharing them with us, with the world? What about the applicant, you know? Don't they want to see what conditions you've
usually
proposed?
our staff and that go through some potential conditions with the applicants
Sure
as
you
part
do.
of the application process. And that my concern there would be, again, you know, that if we take and have somebody here for a gravel pit, conditional use, for example, and we get a lot of public comment and that about truck traffic, hours of operation, dust, berms, whatever, you know, how is our staff able to go back and amend their recommendation to the board, and that when we didn't know that information until the process carried out? And so that's an issue or a concern from the towns as well. And that also, and that by taking and putting that information out there, and that, again, if it's a gravel pit, all the neighbors now are probably gonna look at it and say, oh, look at staff, you know, our land use team is already suggesting approval of this and that. So we come into the hearing, why are we even coming to the hearing? Because they're already approving it, and they're just gonna do what staff's gonna say anyway. That's my fear, and that is that the public will actually look down on this, because why should I come and appeal this? Why should I come and do this? And that when it's already gonna be approved with these conditions, you know?
So you're thinking maybe the public likes it better that you hide the fact that you are about to approve the thing, that your staff report will list conditions for approval?
I think in that the public and that would like to be heard, and that, I think that they would like to have the due process. I would think that they would want to have you guys as the Board of Adjustment make those action items and that, not staff. I don't think in that it's staff's role to be deciding in that how any of those applications are actually approved or denied. I think we're only doing it to try to help the Board of Adjustment, but really the power is within the board members to make those calls.
Yeah, that's axiomatic. And in your decision documents, you always have language about if the board sees fit, here are possible conditions. It's up to the board. The board could add conditions or reduce conditions, but here are the staff suggestions.
Yeah.
And so that document you want to hide from the public until the meeting starts.
I think it creates a perception in that of how the Board of Adjustment on that might act, and that the public doesn't have any say. And I think that is in violation of the intent of the statute, and that's why we do the hearing notice, that's why we take and have a Board of Adjustment, and that is to take and have that due process and make sure that the people are heard, and to, you know, assign appropriate conditions.
Well, I'm very disappointed. I understand you. You've stated your position a couple of times. I understand you. I believe that you are telling us what you will do and won't do, and we'll just have to live with it.
You know, and that I'm willing to take and work with the board, but I mean, a lot of this is a staffing issue. And I mean, I'd like to hear from the consensus of the board, I mean, and that what their thoughts are, you know, and if what we've
Sure.
been doing hasn't been working, you know, and that what we might be able to accommodate.
And we need to give Mr. Wozniak a chance to speak. He's been waiting patiently. So go
Well-
ahead, and then board members, you'll each get a chance. Indeed, a duty to speak. Mr. Wozniak.
Yes, thank you, Mr. Chair. I was going to comment on the appeals. Normally, staff we'd be standing behind the position, administrative position that the staff person took on a, whether it was a permit or a matter that would be subject to appeal. If the board would be considering overturning the decision, what I would suggest, my experience, and we don't deal with many appeals here. I don't think we've had any since in the nearly 5 years I've been here, but I have dealt with them in the past in my career. And usually you're relying on your attorney, your legal advice. So in our case, our corporation counsel. So if you were to be interested in departing from the staff decision and overturning, then you might want to make sure that our corporation counsel is comfortable defending your decision if somebody takes exception to it. So I think you understand that, but that's how I see that point. I'm just going to comment generally. Through my career as someone older that's worked with different jurisdictions, we've experienced more litigation here, not as much lately, but historically here in the county, whether that's subject to the politics of the area or subject to the amount of rural development that we experience in St. Croix County, which is more than some of our other neighboring counties. It seems like some of the concerns that someone may challenge our decisions are valid. Historically, I've worked in settings where we did provide staff recommendations ahead of time, and we didn't experience negative consequences from that. But it does seem that the attitudes and thoughts are a little different here. And so, what I've been doing, at least in my work and the guidance I've been providing the staff, is to try to strike a balance and have a document prepared, at least for the meeting, that would reflect the staff's best wisdom on it. We serve at your direction, though, so.
Board members, you have comments?
I understand what you're saying, Buck, and I like it when they kind of give us a synopsis of what they're thinking, what the staff is thinking. But I also am well aware people are very sensitive about unelected bureaucrats making decisions that they have no right to make. And along what Jason is saying, that, I can see that both sides of that. Why do I forget that?
Just to oversimplify my thoughts, open meeting laws are there because they're there, and to me, the perception, I agree with Buck's principles. It kind of bothers me that we have to feel that we have to hide something, and that's the appearance it would give me that we're hiding something. We don't want to publish it too soon because people will see it. And if that's going to give somebody the perception that, hey, they don't want to see that because they're going to try and push something through. So why not publish it and don't be afraid to say what, it's not in concrete, could be changed. So just my oversimplified thoughts, sorry.
I guess it's my turn.
Yes, sir.
I like the concept of having a suggestion here when we get here of what would be suggested that we do. I like that idea, especially on the conditional use permits, so forth. I understand what you're saying, Jason, and I don't want to have too much information ahead of time in that respect as conclusions. So I can see both, but maybe a hybrid of both. So.
Yeah, and so I have no problem providing a suggestion on how the board might act and, findings of fact and conclusions of law at the meeting and that, but I've actually, in my short career, I've actually been challenged on the fact that I had a predetermined outcome. And literally what they did in that throughout the court proceedings is they asked for my computer history, my Microsoft Word version, and I was literally amending the staff suggestion and that during the public hearing. And so that's what threw that out. And that is because that it was not predetermined, it was not published, and that there were literally modifications because this was a 3-day public hearing and that it was on a big trap rock quarry and that we had probably almost 300 people in the room, So there was a lot of information that was coming out and the property had a lot of history. And so some of these things are very elementary and very easy to maybe decide on, but other things are much more complex. And there's going to be information that comes, and that's why you guys postpone sometimes or table is because you don't have enough information. Well, think about staff when they're doing this a week before the meeting. They don't have enough information to do it right either. So, and that I get to do have Heather Amos.
See why you would be gun shy after going through that kind of a personal experience. All of us are informed, in our actions in the future are always informed by the experiences we've had in the past. And I empathize with you. That's one of the most painful things about your professional field is that you may get cross-examined and it's very painful. Yeah, bound to change your thought. Well, the only way I could see to insulate staff from the attack of having pre-decided variances was for you to provide a document, work up a document so that in your Microsoft records, there was one that would lead to approval of the variance and one that would lead to denial of the variance, and they each picked up the respective facts that supported either side. So that you would have 2 draft decision documents, always pending the new facts that come in the hearing, of course. But you would have 2 documents. So that's why I suggested that for variances.
But you would want that published in the packet?
That I could live without. It could go either way. Dave makes the same point that I did earlier. I think your credibility is better if you aren't withholding it,
Okay.
which is the way it looks to the public.
And so then my concern legally would come into play because we would be publishing and that both action items, approve, deny, and we would literally be giving another attorney, and that, let's say the variance isn't approved, let's say it's denied, and that we would literally be writing the script for them to appeal us because we would be, as staff, answering the 3 variance criteria and that for that action, and we would be publishing that out there for the whole world to see. And that is like, oh, well, it's not approved, but this is why you should take and approve of it. It's right there, so I mean.
Yeah, well,
have
here's
some
the best case for granting it. Here's the best case for not granting the variance.
And so the expertise of our
Do
staff.
do we
then-
really think we're so good that no attorney can think of those things?
I-
Possibly, but it's unlikely. I mean, they work for a client who's shouting in their ear all the time, the reasons why the variance should be granted.
Well, I think it's gonna take, and if that's really what you want to do, and I think you will probably see more of any decisions where they're not being approved, probably appealed, because now members of the public and that lay people and that are gonna say, oh, look at this, this is why my application should have been approved, and that, but yet they denied it. It's gonna be right there, and it's gonna be county staff with some expertise, I think we're professionals, and that are gonna be telling them a reason why they should be appealing it.
But you recognize that what you will be forced to do then is to prepare no decision documents in advance on variances. Because any document you prepare will be used against you as evidence of bias.
That's correct. That's why we're taking and bringing those documents on the day of the hearing, and we're not taking and having that predetermined outcome in the packet.
But you still can be accused of the bias because you've stated it in one direction, not the other.
Well, and Mr. Chair, you bring up a good point. I'd love it if our staff didn't suggest any actions for the Board of Adjustment. I would love that, and I truly believe that is what the statute intends, and that's what the duties of the Board of Adjustment are to do, is to take and create those actions.
Yep, it's up
Absolutely.
to us to make the decision and to not be swayed by your suggestions. At one time, our bylaws said we weren't allowed to talk to staff.
So,
Well,
Yep.
I'm kind of worried that we're getting too tied into the staff. We're not as, where you're talking. I think we need to keep that independence that we have. I don't see the conflict with the conditional use permit per se, but anything else that they're recommending to us, I don't think we should have that until the hearing.
Well, until some stage, probably after the hearing is closed, when what we've done sometimes is we take a kind of trial vote, or we fill out the form that comes recommended from Clue, and then we each say, so we reach a yes or no, but details to be worked out type of decision. And then the decision document is brought to us, if it happens to be consistent with our
I mean, there's no.
trial vote.
There's no, to me, it sounds like we're trying to rush the approval process and get the signature done the same day. We don't need to do that.
No, and we rarely do, honestly, because there's almost always
That's what
some
it seems like.
typos.
We're trying to,
That should not drive the process.
but that's what I'm hearing, so.
Yeah.
So I agree with what you're saying,
totally
Jason.
on board in that we can take and draft the documents in that, following the meeting. We can even ask questions on that. So, okay, what does the board think unnecessary hardship for this application was? And then you can provide us an answer. That'll create a very solid record if you were to be appealed to the courts. And that, what do you think the physical property features are that limit this type of development are? And you can just respond to us, and that creates a solid stance, and that, because then it's coming directly from the board, it's not coming from staff, and then the whole due process, the public hearing, the noticing, all of that stuff that is required by statute is followed to the T.
It just makes our job harder. Dave, there's nothing we can look at that gives us a quick answer.
But we would still be providing a good staff report like we have.
Oh, of
And that
course.
with the property information, the facts and the features of the property and everything, lots of pictures. I would like to do a lot more pictures and big pictures, and that's so that you can see the site. And so that's one of the things and that we'll improve on. But that's all gonna be in the packet, gonna be completely available. And that staff, we're not gonna hide our opinion, you know, and that we're gonna try to advise applicants correctly, because maybe you can't do it that way, but maybe if you just make a couple small tweaks, maybe you can do it this way and it'll comply with the ordinance. That's our new model and that we try to work with people. And so anyway, that's kind of how we do things before the application is even filled out, before they've paid any fees, done the hearing, anything. So we're trying to help people and that through that process.
I think we've got a consensus here that with respect to variances, the board will not see a draft decision document until after the hearing is closed. And the staff will do whatever they want to do in the background in their professional way, recognizing that they are always vulnerable to the criticism that they have made up their mind ahead of time. But the link between the staff and the board will only occur after the board has made its go or no-go decision. Right? Is that the way you understand it? Can we live with that? We're going to try to live with it anyway. Heather, do you want to be heard? I appreciate your being here and really want to hear from you if you've got, as you always do, some good things to say.
Yes, I was listening to the meeting. I do agree with Jason not having the decision documents in the packet, just because I don't want the Board of Adjustment to be prejudged or predetermined that this is what the department says, so this is what the board should do. And I'm not saying the board does that, but it creates at least an appearance of neutrality, that you are not basing your decision on what the community development department may have put in the packet. And so I do agree that the decision documents for variances especially should not be in the packet. In the rules governing the board, it does indicate that, you know, the Board of Adjustment is an independent decision-making body. You shall act in a fair and impartial manner without bias or prejudice and render your decisions based on law, facts, and rational analysis. And I don't think you get all the facts until you come to the public hearing that day. And so I agree with what Jason and Mike have said, is that there are a lot of facts that they don't know. One, because the DNR hasn't been giving us their opinions until about the day or the day of the Board of Adjustment. So I think it creates a better record for if the case is appealed to the circuit court. The staff obviously will give their recommendations during their staff report, during the public hearing, so everybody hears, and it allows for the board to ask them questions also. So I do agree with that. I listened to the conversation on appeals and conditional use permits. Obviously, the staff can put in their staff report what conditions would be recommended if the board were to approve the conditional use permit. As for the staff creating the documents ahead of time, obviously they can create the decision documents with all the facts in there and just not have any information regarding a decision. It's unfortunate that Jason's, records were required to be used in that circuit court case. I think I would have some objections to that's staff notes and not an official record and shouldn't have been disclosed to the circuit court, but obviously that was another county, not my case. But overall, for due process rights of the applicant and just to protect the Community Development Department and protect the Board of Adjustment for any, people indicating that there's collusion or the board is only doing what the department wants, I think it creates an appearance to the public that it's very neutral and there's been no predetermination made by the board.
I just want to be sure the record is clear. I think you misspoke. During the staff report, on our new process, the staff will not indicate its opinion on whether a variance should be granted or not granted.
I may have misspoke. Sorry about that.
So staff will be very careful that there's no bias, no predetermination included in the staff report for a variance.
Okay.
Yeah, I think we're all comfortable with that. It's the ideal world that we're trying to get closer and closer, and we will not task the staff with trying to draft a pro and a con decision document. It's just too much work. They don't have the time for it. And It's a concept that lawyers learn to handle, having two viewpoints at the same time, but most folks don't. And so we won't do it either.
And I think that staff is very good, like during the board meetings, if they hear another fact that comes up, they can quickly type it in. Obviously, all the staff here are very used to the documents they work on, so that's helpful. It may, like you said, it may not be signed the same day as the decision, but at least it will show that there's no prejudgment, and I think that's important if there was an appeal made to the circuit court.
I was just going to say, you may spend a little more time working on, working through the, maybe the findings, the conclusions, and the any conditions on a variance. But, you know, the number of variance applications you get year to year, you know, it fluctuates. This year, we only had 4 variances. Other years, more. So, yeah, a lot more conditional use permits so far this year anyways, just as a point of reference for you.
Knocking on wood. That we don't get buried in a new mass of it's our job to deal with them, but it is more work. I predict that the time where we will spend more time is that analysis part of the 3 criteria before we get to the go or no-go decision. Heather, you kind of like the templates that the CLU has, don't you?
Yes,
We've used them in some cases that we knew were going to be tough ones.
I think those are helpful, even for staff or the Board of Adjustment members, you know, if you review the packets beforehand and do a site visit, to write your notes on those documents if you have any opinions, you know, about unnecessary hardship. And so I think those are helpful documents.
So let's make those available, Julie. Now recognize board members, and I speak, you know, to you and for myself. When we are contested, when we are appealed to the circuit court, they use a transcript of our words. And so even if you end up at the end voting in favor of a variance for reason A, your question asked during the question period about B, where you seem to be taking the opposite side of an issue, will be used in court against us. Just, you know, as Jason said, they got into his files and they were able to pick the points that were in favor and the points that were against, and then they say, well, all the time, you know, it should have been this decision because here's the reason that supports it. So, you know, you ask a question, Dave, about how many trees will be cut down. That sounds like maybe you're opposed to granting that application because you don't want to lose those trees. That'll come back. Not necessarily to haunt us, this being the Halloween season, but it will be used to demonstrate that a board member took this position and then he took that position later on. But that's fair.
How would I know that until the final decision is made?
If you've already made up if at that point you are tentatively deciding that you're going to go yes or you're going to go no, you can match your questions to that. But if you change your mind after that, new facts come in, new arguments, Dave is really persuasive about something, then you can't help it. So,
Brings to mind that no longer board member that said after one of the hearings was buying the beer and that came out.
oh, yeah, we always got to be careful about things that make it seem as though we're not being serious, as though we're not paying attention, we're not listening. You know, that undermines our credibility. Anything else, Heather?
No, nothing.
Jason, anything else? Sure, no.
Use your microphone.
Why don't you use your mic? Make it part of the record.
Theoretically, I own a piece of property and I want to put a structure on it and I require more than one variance. If I'm turned down, is that the taking of property?
No. You see, that's been fought all the way to the United States Supreme Court. In fact, even the case against St. Croix County, which we won, a few years ago in the spring, they raised that question. Is that a taking of property? No, not if it's within certain guidelines, and that's why we have to, one of the reasons why we have to follow the guidelines. No, in that limited way, the Supreme, correct me if I'm wrong, but in that limited way, the Supreme Court has said that the protection of private property rights can be managed a bit for the common good without it being a taking for which compensation should be paid.
Sometimes it comes down to, can you make some reasonable use of the property that is something that would be allowed in the district you're located in?
Yeah, sure. Like, you know, could you put trailer houses during the summer season on that property down on the river where we couldn't find a way to put a house on it? Yeah. Is that a reasonable use then? Sure, it's a kind of a vacation property.
Agreed.
All right. Maybe we've exhausted this subject. Okay, everybody been heard who wants to be? We need to talk a little bit about schedules now, don't we?
Who's cooking the turkey?
Yes, Mr. Chair. Is there any request for future agenda items from the board? Okay. So I do have an announcement for you. On December 18th, our own Julie Peterson here set up a Board of Adjustment training and also a Planning Commission / Town Board training. That'll be at the Baldwin Ag Building if any of you are interested for that event. It's completely free and it's from 1:30 to 4:30. So it's a 3-hour training that will be put on by the Center of Land Use and Education, CLU. And I'm sure Lynn Markham will be the one that'll be presenting. Heather has generously took and volunteered some of her time to take and go over Robert's Rules of Order, parliamentary procedures, that kind of stuff. So that'll be great. So that is something. Also for announcements, we need to take and decide. Well, I guess that's next on the agenda, but for announcements, we're working through an amendment to Chapter 11. That's the animal waste storage ordinance. And we're going to be having a stakeholder meeting with the ag producers and with the folks that are in support of the amendments, and then on December 12th. And so that's coming. We're also working on an amendment to Chapter 15 with the committee that will have a couple more committee meetings and that, and maybe a public hearing in December with early approval sometime next year is kind of what we're hoping there.
Are we paying per diem and mileage for the training session at the Ag Building?
Yes, yep. 18th of December, 1:30 to 4:30, yep. It's right in the front doors as you come in the Baldwin Ag Center there. And that's what I've got for announcements. And then we need to talk about when you would like to meet, probably in November and December.
Do you need a head count for the 18th, Julie, or do you care? No lunch involved, so probably don't need a head count.
We will have an electronic sign up, but if you want to avoid that, you can just let me know and I can make sure you have a seat.
I'm available.
Yeah, you can mark me down.
Okay, so let's see, our normal meeting in November would be the 28th, which is Thanksgiving. I'm not going to be in town. So what do you propose, Jason?
What about pushing it back a week in that, so it'd be December 5th? Might be iffy.
Going to be recovering from some surgery. Don't know how long yet.
Okay. So, well, I guess we can cross that bridge when we get there.
Yeah, I'll be around. Yeah.
Be around.
You
Okay.
you going to Nashville this year?
No, I just came back, but I have a granddaughter getting married, my only granddaughter on the 28th of December. So,
6th, or on the 5th.
So the
would be good.
5th looked like we'd have three
Probably.
of us,
Probably work.
and maybe four.
Okay.
It looks like we'll have, pardon, it looks like we have one application that would have been considered at the November meeting, so whenever it's scheduled, just for your interest.
Okay, and then, we need to adjust the December meeting?
That is the day after Christmas would be our normal meeting day.
Yeah.
And if we bump that one back a week, then it's the day after New Year's. So do we want to push that one to the 9th of January? Or do we just not want to have that meeting, or do we just want to go back to our normal schedule and just do the 4th Thursday of January? Which would be,
Too early to tell the workload, huh?
which would be the 23rd. Well, as long as we just advise applicants, and then I think they'll be understanding because of the holidays.
Yeah, usually a lot
But
going
they
on in
might
January.
prefer to, suppose we tentatively schedule it for the 9th, but we cancel if the applicants are willing?
Okay. Okay.
Is that really workable?
Absolutely.
Okay.
it's my grandson that's getting married. The only reason I mentioned it, my wife would have a fit if she heard me say that.
Well, have her talk to Mr. Telejohn. And all our meetings are now at 8:30, since we,
Yeah, just,
good. Yeah,
yeah, too early.
Could be 7:30, you ask me.
anything else we should talk about for the good of the order?
No.
See, it's 10:54 a.m. Looks like we're ready to adjourn, huh? Okay, I declare us adjourned.
Thank you.
Thank
that
you,
was
thank
fun.
you all.